This is an AZCourtHelp legal talk on probate and estate planning by Carrie Rednour of Rednour Law Office in Tucson, filmed on May 11th, 2022. Thank you.
So this is a talk about estate planning and probate. So I will just get to it. We'll start talking about estate planning because that kind of dovetails into probate and what the issues are with regard to probate. And so we're going to start talking about estate planning. So estate planning is wills, trusts, and powers of attorney. So a will is where you say in the document what you want to have happen with your assets at your death. And you also name someone to be in charge of your assets and taking care of your affairs when you die. So a lot of times people think that that's called an executor, and it is in a lot of states, but in Arizona, we call it a personal representative. So the personal representative is the person who's going to take care of doing everything that you say in the will. So taking care of all of your selling everything and dividing it however you want it divided. So it's very important that you pick somebody to be the personal representative that you trust and that you think is going to do a good job. Otherwise, there could be some problems there. So the will needs to cover who's getting your assets when you die. So how are those going to be divided up? Is it going to go equally to your kids or to a charity or to some other family members? However you want to put that in your will, that's how you're going to do that. And then you're also going to make sure that you name who's going to be in charge of everything. You should also have alternates in case something happens to the people that you've named as the primary people. So an alternate beneficiary and also an alternate personal representative. Just in case something happens to any of them, you have a backup. If you are the parent of a minor child, it's also very important to name in your will who would be the guardian of that minor child. So if something happened to you and the minor child's other parents, who's going to take care of that minor child? It's obviously an important thing to do that in your will so that you feel comfortable that your minor child's going to be taken care of. You can also make some provisions in there. If your child is a minor, you can make a provision for what's going to happen to their share of the money. Minors can't inherit money directly. So it's important that you have somebody that's going to either be their conservator, which we'll talk about later, or somebody who's going to hold the money in trust for the minor's benefit until they reach a certain age. And so all of that can be put in a will. A will has to be probated. That's actually the definition of probate, is the administration of someone's will. So when people say, oh, I have a will, so therefore I avoid probate, that's not the case. It's actually sort of the opposite, I would say. So a lot of people, there's a lot of misinformation out there about probate and about how difficult it is and how lengthy it is and expensive it is. In Arizona, it's really not terrible. The probate process is basically some court paperwork that gets filed. Sometimes there has to be a court hearing depending on the circumstances, but if everything is in order, you probably don't need a court hearing. It's just some paperwork that gets presented to the court. A judge doesn't get involved at that point. And again, unless there's a problem. And the person that's going to be in charge of the estate gets appointed, and then they have the authority to do whatever needs to be done to administer your estate. So they would have the authority to go and liquidate bank accounts, sell your house, do any of those things. And the reason they have that authority is through the court, because the court has reviewed the will and the other documents that have to be filed and determined that that person has the authority to do those things. It's a little more complicated in the sense that there's some other things that have to be done after the person's appointed as the personal representative. But it's really, in Arizona, it is a very straightforward process. Now, other states are not necessarily like that. Doing a probate in California, for example, is very difficult, and it does take a very, very long time. And so if you have some property in California, or you have some reason why you might have to have a California probate, it's very important that you do try to avoid a probate in California. avoiding a probate in Arizona, some people still want to do that, and that's obviously perfectly fine to avoid the hassle of going through it, even though it's not as terrible as it can be in other states. Some people still want to avoid a probate, which is perfectly fine. So there are ways to avoid having to go through probate. One of those ways is simply to have beneficiaries on all of your accounts. So if you have, say you have an investment account with Charles Schwab, you can name a beneficiary on your Charles Schwab account. That then becomes a contract between you and Charles Schwab, and they are obligated to pay whatever's in your account to those beneficiaries directly at your death. It does not go through your will. It does not go through your trust. It doesn't go, it's a contract you have with Charles Schwab. They must pay to whoever you've written it down. So if you write down that you want to give that Charles Schwab account to your 2 kids, and your will says, well, I give everything to a charity, it doesn't matter what the will says. The charity doesn't get it. The kids are going to get that account. So that's a way to avoid probate, because you can just designate it directly with Charles Schwab or Vanguard or Merrill Lynch or whoever your accounts are with. You can just do that directly with them, and it becomes a contract with them. So that can take care of your accounts if you're interested in doing it that way. Your house in Arizona, we have what's called a beneficiary deed for your house. So it's the same thing, only it's on your house. The difference with a beneficiary deed versus the account is that a beneficiary deed, you cannot, it means that the people that you've named as the beneficiaries now own the house together. There was no way to divide that interest up because it's a house, right? So in contrast, on your Charles Schwab account, maybe you have $500,000 in that Charles Schwab account. That's pretty easy to either just liquidate and half goes to one kid and half goes to the other kid, or actually just have Charles Schwab divide up the stocks directly and each person can have their own account with half of the stocks in. You can't really do that with a house. So the 2 people, let's say you're naming 2 people on this beneficiary deed, they're going to own that house together. That, as you can imagine, can create some difficulties, and I have seen that. I don't do beneficiary deeds for people with more than 2 beneficiaries because I think it is just ripe for a disaster, and I'm not interested in getting involved in that because I've seen it where it does not work out. So even 2 people obviously can be problematic, but the more people you add in, the more likely there's going to be a problem, because the beneficiary deed means they now own that house together. And so they have to agree on if it's sold, when it's sold, how much it's sold for, and more importantly, who's going to pay those expenses in the meantime. Because you still have to pay the taxes, you still have to pay the insurance, you still have to keep the utilities on if you're planning to sell it. So who's going to pay all those expenses in the meantime? There's not one person who's in charge at that point because all the beneficiaries just own the house together. So the beneficiary deed is a great tool, and it's a really great way to avoid a probate and transfer some property directly very easily. But you do have to be very careful if you have multiple beneficiaries that could cause a problem. So just be aware of that. And then the last way, actually, before I go on to a trust, I do want to say some people think that a good way to do estate planning is to simply add their children on to their accounts as an owner. And that is not a good thing to do. And I strongly, strongly advise against doing that. When you add someone other than your spouse, as a joint owner on your bank account, they are a joint owner. So they can go to the bank and take out all the money. They can do whatever they want with that account. It also means that if they were sued or filed for bankruptcy or involved in a divorce or something like that, that is considered their asset as well. So the creditor can come after that, the spouse can come after that, even though it might be all your money. With their name as a joint owner on it, it makes it very vulnerable. And I've said this for years and years, and I actually had that case, and it was a nightmare for the person who put their daughter on as a joint owner. So I would strongly advise against doing that. The way to do it is to have a power of attorney, which I'll talk about in a little bit, and again, have a beneficiary on that account. So that gets you to the same place without having the problem of having a joint ownership on that account. So, so do not do that as a form of estate planning. Have a beneficiary deed, or you can also set up a trust. So a trust is basically just a will substitute, in the sense that the trust is going to have all the provisions in it about what you want to have happen to your estate at your death. Who gets everything, how it's set up, who's going to be in charge. The person in charge of the trust is called the trustee. The idea behind setting up a trust is that you put all of your assets in the trust while you're alive. That is what avoids a probate. And if you do it correctly, it will avoid a probate. Some people spend all the money to set up a trust, and then they don't put their assets, or they don't get all of their assets into the trust, and then they have a probate anyway. So that's very important to make sure that you understand what you have to do in order to make sure that you get what you want as far as the trust goes. A trust is much more flexible than a will, in the sense that you can pretty much put in a trust any kind of provisions that you want. If you, as an example, have some kids and you want them to get the funds, but you don't want them to get the funds until they're a certain age, you can stretch out the distributions until they're that age. So maybe you say, well, you know, they get half at 25 and a quarter at 30 and a quarter at 35. You can do that very easily in a trust. It's very cumbersome and difficult to do that in a will, just because of the way it has to be probated, and then you have to keep the probate open, and that becomes very difficult. So a trust is a great way to do that. A trust is a great way if you're in a second marriage situation and you want to make sure that your kids are protected at the second person's death. If you're the first to die and you want to make sure that that your spouse doesn't exclude your kids after you're gone, a trust is a great way to make sure that happens. A trust is really a good tool to use if you have a disabled beneficiary. There's a special needs trust that you can put inside of a trust to make sure that that disabled beneficiary continues to receive government benefits, because people that are receiving government benefits for the most part cannot inherit money, but there is a way that you can get them funds through a special needs trust if you do that correctly. So that can all be done in a trust. Perhaps one of your beneficiaries is not disabled, but they have a spending problem, or they have a substance abuse problem, or some other problem in which you believe that it's probably not a good idea for them to get a large sum of money all at one time. So again, you can have the money held in trust for pretty much any length of time that you want. It can be years and years. It can be their lifetime. It can be whatever makes sense for your particular situation. And so that's a great use of a trust. So and like I said before, if you have property in another state, it's probably a really good idea to have a trust, particularly if you have property in California or any state where it's going to be a difficult probate process. I just tell people, if you have property in another state, you definitely want to be looking at a trust, because I don't know what the probate situation is in every state. So I can tell you, though, if it's in a trust, then you don't have to worry about it. You know, some people don't have any of those issues and they just want to leave it all to their kids outright. And so what should they do? And that's really more of a personal preference. I don't think you can really make a bad decision. It just depends on what you're most comfortable with. A trust does allow a pretty smooth transition when something happens to you. But like I said, doing a probate in Arizona is not horrible. It does create another step in which your personal representative has to go to court and submit some paperwork and do that. So it's just that little bit of an extra step in having to do those papers with the court. But a trust is more expensive now, and a probate's going to be more expensive later. So it really comes down to, well, what do you think? Do you want to spend more now, or do you want to spend more later? So those are the basics between a will and a trust and other estate planning vehicles that I mentioned, like just doing beneficiary deeds or naming beneficiaries on your accounts, which again avoids a probate. So keeping in mind what is subject to probate? What's subject to probate is anything that's just in your name at the time of your death. So anything that has a joint owner on it, anything that has a beneficiary, anything that's titled in the name of the trust, those are not subject to probate. So whatever you have at your death that's just in your name is what is subject to probate. So that's the gist of wills and trusts. And then I do want to mention powers of attorney because they are very important. So that the will and trust, for the most part, the trust comes into play at your death. So that's what we've been talking about so far. What happens if you're alive, but you're incapacitated? So you can't make any decisions for yourself. Somebody needs to help you out. And maybe that's that you're in an accident. Maybe you are aging and you've developed dementia or some other cognitive deficit and you can't make decisions for yourself anymore. What happens then? If you have nothing, so if you don't have any powers of attorney or anything, then what's going to happen is someone, whoever's going to help you and take care of you, is going to have to go to court and become your guardian or your conservator. So a guardian is over you as a person, medical decisions, where you live, what happens with you as a person. Conservator is over your money. How are your bills being paid? Does your house need to be sold? Do your accounts need to be liquidated? What needs to happen in order to take care of you? So a guardianship and a conservatorship is a court process. And while I said probate is, not too big of a deal, guardianship and conservatorship is a pretty big deal. It is, the court is basically involved at all steps in a guardianship and conservatorship. There's an attorney that gets appointed to represent you. There's an investigator that gets appointed. There's a lot of stuff that goes on with a guardianship and conservatorship. So generally speaking, if you can avoid a guardianship or conservatorship, you should. There's a lot of things that go along with a conservatorship. The person that's a conservator has to be bonded. There's really no way around that, which is an insurance policy that ensures that the conservator, if the conservator were to steal your money or mismanage your money, that you'd be paid back. There are annual accountings that have to be done with the court, which are not easy to do. Sounds like it would be easy, but it's not. There's certain court forms that have to be prepared. And it's not very user friendly. So while I said that I don't think you could really make a bad decision on whether probate or trust, because it probably, depending on your circumstances, obviously, it's probably all going to work out to be okay. You do want to try to avoid a guardianship and conservatorship if at all costs. So what's the way to do that? So the way to avoid a guardianship and conservatorship is to have powers of attorney. Like I said, a guardian is the person that's appointed by the court to take care of you as a person. So the equivalent to a guardianship is a medical power of attorney. That's where you sign that now. While you have capacity, while you know what you're doing, you name someone or multiple people to make medical decisions if you can't. So it's a good idea to have a primary person that you're naming and also an alternate, just in case something happens to that primary person. And what you're saying is that anytime you can't make medical decisions for yourself, you're asking that this person do it for you. Now, that's anytime you can't make medical decisions. So it might be an end of life situation, but it might also be anytime you can't communicate. So maybe you're just in the hospital having a surgery, maybe you fell down and you're unconscious, something like that. That person can step in and make whatever decision needs to be made. Maybe the doctors need them to consent for you to have a surgery. Maybe you're just making, any kind of regular routine medical decisions. What goes along with a medical power of attorney is also a living will. So a living will, which you've probably heard of, is a document where you are making choices about end of life stuff. And this is end of life. This is when when you're in a terminal state and the doctors think you're not going to recover. A living will is your wishes, basically, about, do you want to be on life support? Do you want to be on a ventilator? Do you want to be have a feeding tube, all those kinds of things. the living will is not legally binding in the sense that you could put everything, you could make all these choices on your living will in which you say, I don't want to be on any machines. I don't want any of those measures taken. If the person you named in your healthcare power of attorney says, no, I want them hooked up to every machine possible. I want them kept alive as long as possible. That's what's going to happen. Because the doctors want to listen to a person and they don't want to get sued by that person, right? So they are going to do whatever that person's telling them. So it's a good idea to have a living will because, you know, if the person you're naming has to make that decision, that's a very difficult decision. And you want to give them some comfort and some guidance about what you want. And so it's a really good document to have, but with the understanding that ultimately it's going to be their decision. So it's a really good idea to have a talk with the person that you're naming and make sure that they are on the same page with you and they are clear that this is what you would want if you're ever in a terminal state and the doctors think you're not going to recover. This is what you want. And also keep in mind, it's when you can't communicate, because as long as you can communicate, then you can make all those decisions. It's only if you're unconscious, you know, you're in a coma, whatever the situation is, and it's an end of life situation, then that's going to apply, and your agent under your medical power of attorney is going to have to make that decision. So it's very important to choose somebody that you think is going to carry out the wishes that you've expressed. So that is for you as a person. And that if you execute a medical power of attorney, hopefully you won't need ever to have a guardian appointed. Now, it's not 100% guaranteed. It's not a situation where you can predict every single circumstance that might arise. So unfortunately, there are times where the medical power of attorney doesn't work and you do have to get a guardianship anyway. And the most common one of that is, let's say that you are let's say you're in the hospital. You go into the hospital for something's happened and you go into the hospital. And then the hospital says, you know, you really can't return home. It's not safe for you to go home. You need to be in a facility. And you don't want to do that because you don't think you need to be in a facility. The person that you've named in your power of attorney cannot override that decision to put you in a facility. They are going to have to go to court and become your guardian in order to do that. Now, if you say, okay, I don't care, I'll go to a facility, then that's no problem. They can go ahead and arrange that and have you moved to the facility, and that's not an issue at all. It's only if you say, no, I am not going to a facility, then the person that you've named is going to have to go to court and become your guardian, because the facility will not admit you over your own objection. So just keep that in mind. There's no way to plan for that, obviously, because you don't know what circumstance that's going to come up in. You don't know if that's going to happen to you. You don't know what your reaction is going to be if that ever happened to you. So there's no way to plan for that. Again, the best thing you can do is just have the power of attorney, and hopefully, if the time ever came, it would all work out the way it needs to work out, and you wouldn't have to have a guardian. So on the other side of that, there's the conservatorship. So that's over your money. So if you don't have any documents in place, you would need to have a conservatorship if someone needed to take over your finances for you. And again, all of your finances, writing checks, paying bills, selling your house, liquidating any of your accounts, and pretty much contacting any bank about your account. The bank's not going to tell that person anything unless you have a power of attorney. So that's called a general or a financial power of attorney. So that's, again, you name somebody to take care of your finances when you can't. So there's two types of those. There's a regular just power of attorney that's effective immediately. And then there's what's called a springing power of attorney. So a springing power of attorney is, it springs into effect when some action has happened. So normally, the way that you determine that a springing power of attorney is going to come into effect is to have a doctor or two doctors write a letter saying you can't manage your finances anymore. I don't particularly like to write those because it's very difficult. It can be very, very difficult for your agent to get a letter from a doctor saying you can't take care of your finances anymore, let alone trying to get 2 doctors to certify that. I tell people, if you're very concerned about this and you're concerned that that's an issue for the person that you're naming, that you're concerned that they're going to use this power of attorney too early, you probably shouldn't be naming that person. If you don't trust them enough to have the power of attorney effective immediately, you probably should think more about that and not name that person. That's just my personal opinion, because it can be very difficult to get a doctor to do that. Because now you're also in, there's a HIPAA violations, there's all those kinds of things, and doctors don't like to get involved in that. So that's just my suggestion. But a financial power of attorney should cover all of your finances, signing tax returns, paying bills, doing whatever you're with your finances that you could do. So it is a very powerful document. And so it is very important to understand that you are naming somebody to do this, and you're giving them an awful lot of power to do it. So just keep that in mind. They're not very useful in this context. There are other kinds of powers of attorney that you do just for a limited purpose that would have an ending date or that would not survive incapacity. But the powers of attorney that we're talking about should all be durable, because that's the point. You want them to apply when you're incapacitated. So those are the basic estate planning documents that you should be aware of, and you should probably be considering when you're working on your own documents, because that's what is going to help you make sure everything's in order and avoid a probate or avoid a guardianship or conservatorship. Back to the conservatorship. So having a financial power of attorney hopefully will avoid the need for the conservatorship and having to go to court and have someone appointed your conservator. There are instances in which that is not 100% either. And the difference between a conservatorship, one of the differences between a conservatorship and a power of attorney. A power of attorney is a consensual arrangement. So meaning that you can revoke that power of attorney at any time. A guardianship and conservatorship is not a consensual arrangement. That is a court order. It is ordered by the court. It's not something you can just say, well, I don't feel like having that anymore, I'm going to get rid of it. That's not the way that it works. So that's a big distinction. And so going along with that, if you have a financial power of attorney and you've named somebody as your agent under your financial power of attorney, that person cannot restrict you from your own bank account. They can have access to your bank account, but they cannot restrict you. So, and this happens quite frequently. Someone has developed dementia or something's going on with them, and they've now taken to giving money away, whether it's to one of these, lottery scams or just a family member that's taking advantage of them or anything like that. When you have a power of attorney, the power of attorney cannot prevent that from happening because they cannot restrict the person's access to their own bank account. So they can be, they can get duplicate statements, they can go into the bank and conduct business, but they cannot prevent you or the person who executed the power of attorney from also doing your own banking business. So in those cases, you almost always have to get a conservatorship in order to stop that from happening. In a conservatorship, you, the person, do not have any power over that bank account. Only the conservator can deal with that bank account. So they can restrict the access, meaning they can prevent you from giving all your money away to the Nigerian lottery or to these family members that are taking advantage of you or whatever the situation is. So that's where it comes up in a conservatorship. Is a lot of times there is really no option. You have to do a conservatorship in order to stop that predatory behavior from continuing. In order to execute any of these documents, power of attorney, will, trust, you have to have capacity. So there can be some issues there if somebody, again, has dementia, or perhaps it's somebody with a a cognitive delay or anything that gives rise to whether they are competent or have capacity, they probably cannot sign these documents. So that's why it's very important to have done this in advance, because if something were to happen to you, it might be too late to sign the powers of attorney, to do a will, to do a trust. So you should be thinking ahead and making sure you have all your documents in order. Same thing about amending them. Once you've done them, as long as you have capacity, you can amend them. But once you no longer have capacity, you can no longer amend those documents. Oh, a do not resuscitate form. So a DNR is a little different from the living will. So when I was talking about the living will earlier, that can take pretty much any form you want. There's a document out there, if you Google it, called 5 Wishes, where it has all kinds of information about what you would want if you were in an end of life situation, to the type of music that's playing, to what's around you in your room. I mean, all sorts of stuff. And that's I think that's great. And I think, again, as long as the person that you're naming is your agent to take care of all that, you've had a conversation with them and they can facilitate all that. I think that's wonderful. A do not resuscitate or a DNR form is different. A DNR is actually something where first of all, you have to get it from your doctor, because your doctor has to sign off on it that they've talked to you about it. And that's an orange card that gets put on your refrigerator. The purpose of that is if the paramedics, if 911 is called and you're at your home and 911 is called and the paramedics come in and they see that orange card, they're not going to resuscitate you. So that's the limited specific use that is for. So, and the theory is that a doctor needs to have talked to you about it to make sure that you understand what that means, because they literally won't do anything. If you don't have that orange card, they're going to do whatever they can to revive you and then take you to a hospital, because it's an emergency, right? So they're going to do whatever they can to keep you alive, and then they're going to take you to a hospital, presumably. And at that point, then your agent would be called, and then they could make those decisions about what happens next. But the DNR is specifically for that emergency situation where the paramedics are coming into your house, and it's on orange paper and it has to be on your fridge, because they're not going to search your house. Right? It's an emergency. So they're not going to be searching your house for this card. They're going to look at the fridge. If it's not there, that's it. They're going to do whatever they're trained to do. Thank you.